Get ready for the dictation. Start. The learned Solicitor General then challenged the orders of the division bench of the High Court on the ground of violation of the principles of natural justice. It was contended that while the High Court had concluded the hearing and reserved judgment on 20th July 2011 by order dated 12th October 2011, it is directed the Speaker to place on record the status of the proceedings relating to the disqualification petitions, although the same were duly filed without giving the parties further opportunity of hearing with regard to the said records. The division bench directed the matter to be listed for further consideration on 19th December 2011. It was submitted that though the bench did not assemble on 19th December 2011, the division bench delivered the impugned judgment on 20th December 2011 without any further opportunity of hearing to the parties. The learned Solicitor General submitted that the procedure adopted was contrary to the law laid down in another case wherein it was stated as under. In view of the limited scope of judicial review that is available on account of the finality clause in paragraph 6 and also having regard to the constitutional intendment and the status of the repository of the adjudicatory power, that is Speaker oblique Chairman, judicial review cannot be available at a stage prior to the making of a decision by the Speaker oblique Chairman, and a quick time action would not be permissible, nor would interference be permissible at an in-between stage of the proceedings. Exception will, however, have to be made in respect of cases where disqualification or suspension is imposed during the pendency of the proceedings, and such disqualification or suspension is likely to have grave, immediate, and irreversible repercussions and consequences. The learned Solicitor General sought to re-emphasize the fact that the present case is not a case involving disqualification or suspension of a member of the House by the Speaker during the pendency of the proceedings, but relates to disqualification proceedings pending before the Speaker which were not being disposed of for one reason or the another. It was submitted that the fact that the Speaker had not finalized the disqualification petitions for almost a period of 2 years could not and did not vest the High Court with power to usurp the jurisdiction of the Speaker and to pass interim orders. Stop.